this is a session of closing remarks, but Professor but we'll begin with a speech on a precise topic, when to prosecute for expression, lessons from the counter-terrorism context, that will be given by Professor Martin Scheinin, professor here at the European University Institute, and also a former UN Special Rapporteur of Human Rights and Counter-Terrorism. Professor Scheinin.
Thank you very much, Mr. Chair. It's of course a great honor and pleasure to welcome as one of the professors of this university my former colleague, Frank Laroux, who is now United Nations Special Rapporteur, a position which I had under a different mandate for 6 years. I don't want to delay the proceedings here. Nevertheless, I would like to bring some experience from the context of my former Special Rapporteur mandate as Special Rapporteur on Human Rights and Counterterrorism in relation to freedom of expression. I think there are important corollaries and parallels as to the discussion on hate speech. I listened with great interest to the debate that just finished and noticed that many of the things I wanted to say were said already. But you don't know which ones. So therefore I have to say at least some of them. In the context of counterterrorism, there's of course an immediate challenge, which is what are the proper limits to freedom of expression that will be put in the name of fighting against terrorism. There are forms of expression that need to be criminalized, as for instance incitement to violent forms of terrorism, as incitement to any violent crime. Then there are indirect challenges which relate to the consequences of first criminalizing certain expressions that are seen conducive to terrorism, and those are about prohibiting political parties, associations, electoral lists, closing down newspapers, etc., as a consequence of first having found them siding with terrorism. And of course, these questions are very closely related to the open issue, what is terrorism? How does a particular country define terrorism? Where we often see politically motivated abusive definitions used first to criminalize certain forms of speech, and then as a consequence to close down political parties, newspapers, associations, etc. Hence, you will understand that the question of freedom of expression in relation to combating terrorism is one of the core issues in the discussion on human rights and counterterrorism. Much on the discussion on the relationship between human rights and counterterrorism has focused on so-called facilitating causes of terrorism. We are speaking of modern telecommunications, we are speaking of financing of terrorism, we are speaking of recruitment to terrorism through associations, etc. These are all facilitating causes. Terrorists need networks, money, communication channels, internet in order to prepare and commit their acts of terrorism. And this is the area where there appears a prima facie tension between human rights and effective counterterrorism. The feeling is we need restrictions upon human rights in order to combat effectively these facilitating causes of terrorism. My approach as Special Rapporteur always was that the answer is better law, more law rather than less law. We need more careful articulation, for instance, on permissible limitations to human rights, rather than saying, well, we must balance between the law and security, and if the law does no good, let's get rid of the law. No, we need more law in order to apply it properly. Furthermore, the question of facilitating causes, sometimes requiring limitations to human rights, is not the full story about the relationship between causes of terrorism and human rights, because we see human rights violations as causes of terrorism, both at the level of structural causes, deeply embedded structural human rights violations in divided societies are a hotbed, a recruitment ground to terrorism. So by restricting too much or violating human rights, governments actually create a recruitment ground to terrorism. And the same can be said at the level of facilitating causes, where research shows that individual or family-based experiences of human rights violations such as torture, arbitrary detention, or humiliation at checkpoints may trigger an individual, a bitter individual, to jump from being just a passive, bitter individual to becoming an active terrorist, including a suicide terrorist. So we have actually two parts of the causes of terrorism indicating that human rights violations are a source of terrorism, rather than there would be a tension between the two. I'm moving to freedom of expression. You probably discussed extensively the ways in which human rights law allows for limitations to freedom of expression to combat hate speech or, in my case, terrorism. And to put it very short, I would be among those who dismiss the use of the abuse of rights clause, Article 17 of the European Convention on Human Rights, or the derogation clause, state of emergency. I would insist that the better law approach requires focusing on permissible limitations. So let's apply seriously Article 10 of the European Convention on Human Rights and try to find the toolbox there. In the International Covenant on Civil and Political Rights, we have the additional tool in the box, Article 20, where there is a mandatory restriction clause concerning advocacy of national, racial, or religious hatred or war propaganda. Again, I would be rather restrictive in applying that clause and building more upon Article 19. As to terrorism, we have a specific provision in the Council of Europe Convention on the Prevention of Terrorism, Article 5, which resembles Article 20 of the ICCPR, but is geared towards terrorism. Here, Council of Europe member states commit themselves to making it a criminal offense to distribute or otherwise make available of a message to the public with the intent to incite the commission of a terrorist offense where such conduct, whether or not directly advocating terrorist offenses, causes a danger that one or more such offenses may be committed. This is a problematic provision, and it appears to be much broader than the pertinent United Nations instrument, which would be Security Council Resolution 1624, which calls upon states to prohibit and prevent incitement to commit terrorist acts. There, at the UN level, we have a plain incitement standard, where at the Council of Europe level, we have the odd words in the middle, whether or not directly advocating terrorist offenses. How can you incite and still say whether or not directly advocating? That seems to be a contradiction in terms. It is actually a political compromise between different traditions in different countries, and I have my own view how this should be read, and I'm coming to that. What are the main challenges in the field of applying restrictions to freedom of expression in relation to incitement to terrorism, but easily extendable also to hate speech and genocide denial? The first main challenge is the question of coded language or symbolic speech. Yes, incitement does not need to use words to say, I call you, dear readers, to commit acts of violence. There are forms of expressing the call to violence by indirect means, including through the use of Nazi swastikas or caricatures. They can be inciting in content. Graphic images, photos, etc. Can amount to incitement. And we have the famous case, I don't know how many times it has been mentioned here, Leroy, against France of the European Court of Human Rights, which was about a cartoon published on 12 September 2001, the Twin Towers falling down, and a caption saying, "We all dreamt about it, but Hamas did it." The cartoonist was prosecuted and punished for glorification or apology of terrorism, and the European Court of Human Rights found this to be a permissible limitation. And in doing so, the European Court of Human Rights referred to the Council of Europe Terrorism Prevention Convention, where we find the problematic wording in Article 5, how can you incite if you are not directly advocating, and upheld the conviction. My take on that would be that the European Court of Human Rights was wrong. They should have become convinced that there was a subjective intent to incite and an objective danger, that somebody gets incited, and then symbolic speech should be addressed under the pertinent clauses of the Criminal Code. But we see that the Council of Europe Terrorism Prevention Convention is based on a compromise, including with some countries that have broader terrorism laws than mere incitement, laws that speak about glorification or apology. The Council of Europe Convention has been verbatim repeated in the EU Framework Decision on Combating Terrorism, and as said, was used as basis for far-going restrictions in the Leroy case. In Spain, we have a clause on glorification of terrorism in the Penal Code, which has been used as basis for prosecutions against bars or private demonstrations, including by families, merely exposing the photographs of imprisoned Basque individuals who have been sentenced for terrorist crimes, are serving their prison sentences, and bars in the Basque region expose their photos as a sign of solidarity. Families carry their photos to call for their release. Only in 2010 there were 400 prosecutions in Spain on the basis of public exposure of photographs of prisoners. That is seen as a form of glorification of terrorism, under the understanding that this is a form of symbolic speech where the recipient understands that the message includes at least siding with ETA terrorism. In October 2010, Audiencia Nacional, the nationwide Spanish court dealing with terrorism cases, issued a landmark ruling which called for a cautious application of the glorification provision. They upheld the glorification standard, but said that the mere exposure of photographs should not be assumed to carry the intention of glorification. There might be other motives for carrying the photos, such as expression of empathy, and therefore it shouldn't be presumed, and in this case the persons were acquitted. But that's not the whole story. There are many people who have been convicted as well. Another important case by the same court, also from 2010, is the Egunkaria newspaper case. That was the only Basque language newspaper which was closed down under the membership in terrorist organization clauses of the Spanish Penal Code. Why Egunkaria was closed down was the so-called octopus theory, the octopus having 8 tentacles, ETA having its tentacles everywhere in society, and intentionally using as front people whose connections to ETA cannot be proven. So the newspaper could be closed down because people who were serving in responsible positions couldn't be established having any connections to ETA. Therefore, it was proven that ETA was behind the newspaper, which was published in the Basque language. That ruling was quashed by the Audiencia Nacional, saying that such presumptions are not valid, and one would need stricter standards to decide whether a newspaper or other media outlet is actually controlled by ETA. Mere presumptions cannot be used. In the previous discussion, Russia and the extremism law was already mentioned as a warning example of broad use of terrorism-related action as basis for criminalization. The Russian extremism law has a very long list of acts that are prohibited, and I have chosen just some of them here. Items 4 and 9 appear appealing to this kind of an audience because they are about hate speech proper. Racial superiority, Nazi emblems or similar to them are to be criminalized. At the same time, the same list includes highly problematic elements where item 1 on the face of it looks at violent efforts to change the constitutional order in the Russian Federation, but read together with 10, it will extend to possessing materials that potentially could be used for calls to change the constitutional order if needed with violence. So you can't see it from the materials necessary which are prohibited under item 10, whether force is going to be used or not. And then finally, item 11 has some resemblance to the Spanish octopus theory, because under item 11, it's a form of extremism to blame government officials for criminal acts. So if you say government officials commit a crime, that's on its own an extremist offense. Of course, extremism is a corollary of terrorism, and that's why this piece of legislation falls into the framework I have been addressing. I'm going to finish by referring to a model clause on the offense of incitement to terrorism that is included in the last report I submitted to the United Nations Human Rights Council before finishing my task as Special Rapporteur. It's based on the Council of Europe Prevention of Terrorism Convention, Article 5, but I have merely resolved the seeming contradiction by replacing directly advocating by expressly advocating. The essence of that provision, properly understood, is that it needs to cover also symbolic speech. And therefore, it should not be direct, indirect, it will be implicit, explicit. That is the distinction that matters. So if a court is convinced of the double requirement of subjective intent to incite to terrorism and of the objective danger that somebody gets incited and commits an act of terrorism, then there's reason to convict, even if coded language, symbolic speech was used. To conclude, permissible limitations, better law, is the proper approach to expressions inciting to terrorism, and incitement is the proper standard in applying limitation tests, the double requirement of subjective intent to incite and objective risk that somebody gets incited, and finally, that should include then also instances of symbolic speech where the judge needs to be convinced that also through forms of symbolic speech there was an intent to incite and an objective danger was created that somebody gets incited. My assessment then on truth laws is that on the level of plain reading, it's a mistaken approach, but it can be used as a shorthand to express the task of the judge to assess symbolic speech, whether there is an incitement intent behind the act. And then I find the application of truth laws properly applied, permissible under freedom of expression, but only through the careful reading and application by the court that those two criteria of intent to incite and danger that somebody gets incited was present. And I know I'm in the middle of a discussion which just was going on in this room some minutes ago. Thank you.
Well, I think this section is supposed to continue with Frank Laroux that will give us some general thoughts about this conference. Thank you.
Thank you very much. I always hate when someone tries to summarize, so I promise I won't do that. This has been wonderful 2 days, very, very productive, and I think with great contributions. There's a couple of general conclusions that I think we all agree on, but it oftentimes is important to kind of re-emphasize them. Number one is that hate speech is nothing new, which is why it was established in Article 20 of the ICCPR many years ago. So we're dealing with an old phenomenon, but that has a new potential because of the new technologies. As we said with internet, that it can be a great instrument for broadening the scope of citizen participation, of using freedom of expression, and the added element that it has of being an interactive means of communication, it also raises the risk. It raises the risk of being misused. We talked about things that are happening in the developed world, like cyberbullying among children, all the way to incitement to terrorism or incitement to hatred or to hostility. Plain racist speech that can be used and can be presented over the internet has a much more powerful effect. And I think in this sense, I strongly believe, I agree with my friend Martin, that even symbolic language can actually provoke very serious effects. I think they have to be measured with a caution, because not all symbolic language can necessarily be criminalized. Secondly, I think we have to have a human rights approach at this. And why I say that? Because this brings us to a little bit the legal aspect that Anya raised. Talking about Holocaust denial is not the same in Europe as it may be in India or in Latin America or in any other part of the world, because the symbolism can be different. And then the subtlety of the messages also is different. And I think this is crucial to understand, because when we're dealing with human rights, we're trying to create universal standards that should be applied across the entire world with no cultural relativism. And this is also very, very important. Secondly, and I think that this may be one of the mistakes that those of us that are advocates of free expression always force, is that it gives the impression that we'll be against any limitation to free expression. And that's not the case. My particular position is that legitimate limitations actually enhance freedom of expression, because legitimate limitations eradicate or take away the mistaken forms of expression, which are not done in defense of freedom of expression, because normally people that use hate speech are not necessarily saying that they're defending freedom of expression, are simply just abusing expression in general. And in this, I do apply a norm, which I applied it to internet, but I think is valid to freedom of expression in general, is that first, the general principle of any society has to be the openness. This is why we were talking about the internet being the piazza, in Spanish we would say the plaza pública. Internet has to be the public space where we meet, we mingle, we relate. And here I quoted the UNESCO Constitution saying that it was built as an institution to facilitate the free flow of ideas and knowledge among peoples of the world. So we emphasize that idea of free flow of knowledge, the free flow of ideas and knowledge. So it has to be a very free and open space. So limitations always have to be seen as the exception. They're not the rule, they're the exception. The exception that is very important though, and that clearly has a tremendous legal impact, and it should have, but they are the exception. And they are the exception why? Because the limitations are to have the object of avoiding the misuse of freedom of expression. Those that are abusing a right. And Articles 19 and 20, as Martin was mentioning, are very clear. The limitation to exercising any right in general is when it affects the exercise of other rights by other people. And this is very clear. If freedom of expression is used to detriment of the dignity and the rights of other individuals, then they must be limited. Not only can they be limited, but they must be limited. Now here's where those limitations have to be within, first of all, the human rights framework. The General Comment 34 of the Human Rights Committee makes it very clear that Article 20 has to be understood in the light of Article 19. Why? Because they are reaffirming the principle. The principle of freedom of expression is in Article 19. That's why I always say that the two articles only make sense if they're seen together, never separately. Article 20 has very clear prohibitions. The apology of war, it says, no one can talk about war as something good or beneficial or necessary. Or the prohibition to any speech that incites to hatred, hostility, or violence on the basis of race, nationality, or religion. It's very clear. But those limitations have to be understood under Articles 19, 2, and 3, which establish the principle of what are the legitimate limitations. Now, oftentimes, and here's where many of the limitations come from prohibitions I mentioned yesterday established in human rights instruments themselves. The Convention on the Prevention of Genocide, the optional protocol on the Convention on the Rights of the Child, or the recommendations of CEDAW, or Article 4 of CERD, are all prohibitions that derive from human rights standards. So it would be a mistake to think that prohibitions or limitations are against human rights. No, some of them are necessary to guarantee the exercise of human rights, of equal human rights by all. But they have to be interpreted appropriately, and here's where, as I mentioned, the three-part sort of test. They have to be established by law, which is non-ambiguous, which is very clear. They have to be established, the second aspect, to prevent the violation of other rights or to protect the exercise of other rights. And 3, they have to be absolutely necessary and proportional to the protection of that right. But beyond that, within the Syracuse principles on the ICCPR, one can talk about how clear and unambiguous the law has to be and how clearly defined it has to be established. Because the idea is, yes, all judges interpret the law, that is their function, but if we leave a very vague and sort of muffled legislation, the interpretation can vary too much from judge to judge. The principle is, let's make legislation as clear as possible so the doubts will only be on the events themselves. Now, here's where I make a difference. It's not the same thing to establish what is offensive speech than what is specifically hate speech. And you establish hate speech by the consequences, which are not only violence, I agree. The American standard of the First Amendment is only that is perceived as a clear and present danger of violence and the effects of violence. No, I have more of a European focus in that sense, but it not only is violence, there can be other forms of harm, serious discrimination, serious offense to the dignity of an individual. And I think this should also fall into legitimate limitations, but they still have to be very clearly established. What we must prevent, and this is my role, is that these limitations are never used for political reasons. Oftentimes, the use of hate speech itself is oftentimes done by those groups in power to discriminate against those that they want to marginalize. But at the same time, limitations in the law, including, we used to talk with Martin about this, limitations under the excuse of combating terrorism, which is an absolutely legitimate, not only a function of the state, it's an obligation of the state to guarantee security to all the people in its territory. But oftentimes, anti-terrorism is used in, I mentioned this morning and yesterday how in my country today, indigenous peoples who raise their voices against mining projects are being called terrorists because they come out and freely, peacefully demonstrate in the highways. Peaceful demonstration is part of freedom of expression. And I think it's important to defend this right. So here's where we have to be very clear in how we define these terms and how they can be interpreted. And oftentimes cartoons, and with this I would slightly disagree, I found the Danish cartoons very offensive against the Islamic world, but I would never prohibit them because they were portraying Islam as a terrorist religion. But it is, all cartoons are always a form of mockery, are always in jest of a principle, of an idea. Cartoons are a legitimate form of journalism, even if some people may find them offensive. So we cannot equate offense to hatred, because the idea of hatred is that it generates the hostility, the discrimination that affects the dignity, the rights, the exercise of rights, and eventually the personal integrity and safety of individuals. And this is very important to make this difference. That's why the boundaries are very difficult to define. Where do you jump from offensive speech to hate speech? In the video we were watching before, Susan Benish, a friend of mine who teaches at American University, and we have been working on the hate speech together, but I did tell her that it's a very dangerous, she talks about dangerous speech. I think it's a very dangerous practice to talk about dangerous speech, because either it is hate speech and you prohibit it, or it's not hate speech, and even if you don't like it, you have to allow it. And this is a bit, I think, the interpretation oftentimes of the Audiencia Nacional in Spain and of other courts. I think it's very, very complicated, very, very complicated. Otherwise, what happens is that if we begin falling into the trap of excessive limitation, the remedy will be harsher than the harm that one incident would have provoked. I think that ultimately, if we allow the legislature or the executive limit excessively freedom of expression, then in the name of terrorism, or in the name of protecting children, or in the name of defending national security, many things. I mentioned the case of Thailand yesterday. I found several people in jail because of the laws of lèse majesté, and all of them are called a threat to national security, because offending the king is offending the unity of the nation, and offending that is threatening the security, the national security of the nation. That is unadmissible for me in terms, because all kings are human and can make mistakes, and all kings should submit themselves to public criticism because they are public figures. As a matter of fact, the standard of criticism of public officials should be much higher. I agree in this sense with Article 19 and the memo they prepared on the hate speech consultations. The idea is that we should elevate the threshold. They have the 7 standards. I would encourage everyone to look it up in their website. I think it's very good. Like I said, it's not only they deal with how imminent the danger is, but how possible the danger is, how serious the danger is, how the context is relevant. There's a series of conditions that have to be met in order to prohibit. There's a couple of elements that I always make. I work on children's rights myself, as well as on freedom of expression. And I work on youth violence prevention in my own country. And one of the interesting things that I always mention is that oftentimes many countries, when they have a website that carries child pornography, just want to block the website. And with that, they feel good. And that bothers me. I agree with blocking a website, the child porn. Of course I agree with that. That is a legitimate prohibition. But the real responsibility of the state is to solve the causes and the origins. A website that carries child pornography is normally drafted by people that are part of organized crime. And they are connected to child prostitution and to child trafficking. So the real solution of the state is to, yes, to block the website, but also to investigate and prosecute those responsible as part of organized crime. Because if the state fails to do that, then the state is failing in its responsibilities. If the state only blocks the website, which is a legitimate step to take, but it's insufficient. The state has to follow up with its obligation to find the criminal responsibility of those that ultimately elaborated these materials. And this is a reflection I always make, because otherwise we actually give the states just an easy technical way of silencing. If there is a terrorist message on the website, I am sure they will want to investigate where it came from. They should be blocked, yes, but it should also be investigated who is sending the terrorist messages, where are they coming from, where is this incitement. And the same thing should happen with all the forms of hate speech, including child pornography. And finally, we were talking yesterday that one of the elements that is very important in terms of hate speech is to also use, number one is not all prohibition has to be criminal law. There are different mechanisms of prohibition. And I think some can be civil lawsuits, some can be economic sanctions, others can be forced public correction of statements and apologies. And I think this is important too, because this builds a different culture. And the point I was going to make, as everyone repeated, and I really like that very much, is that the most important aspect that a state should emphasize is the issue of prevention. The real solution is to generate a different culture. It is not the entire solution. I believe that the society of Norway is a society that lives very much at peace and respect, and that didn't prevent this man from committing these horrible atrocities against their own young people. So nothing is foolproof, but it is important that these events should be condemned by society, that any act of hatred or discrimination should be condemned by society, that the social practice be what UNESCO calls the culture of peace, a culture of respect. I never use tolerance because it sounds to me too patronizing, but a culture of respect, a culture of solidarity, a culture of civic relations in a society. That is the crucial phenomenon from the family to the education system onward. Again, I say it's not foolproof, that the legal system has to be in place and effective, but to begin with prevention makes a lot of sense. And in this sense, we mentioned yesterday, I did it and several others mentioned, that even those limitations established in Article 20 have to be expanded. Article 20 talks about hate speech related to race, nationality, and religion. And for me, it would be very important. Obviously, nationality is linked with culture, but I think oftentimes it's important to be more specific. And we have been talking about the cultural diversity of the world and how the element there, everything included in culture, from the language to any other expression of the values and the traditions of the peoples of a nation. But also, we should include the elements of gender and gender equality. We should include the elements of sexual orientation, as we mentioned yesterday, or the issues of people with disability. There are other forms of hate speech that were not contemplated in Article 20 that I believe are legitimate limitations that should be included if an expression can actually generate harm, physical, psychological, or legal harm in terms of the exercise of their rights to these people. So I think the conclusion that we have is, yes, limitations are legitimate. Yes, hate speech does exist. Hate speech leads, in the worst cases, can lead to genocide, but in many other cases leads to having a society divided in several standards of living in tiers. People of second-class citizens with second-class human rights, or rights in general, or no rights, or very little exercise of rights. And I think this is crucial to correct this situation, and to actually talk about the equity in terms of and the universality in terms of the exercise of rights, which is all the basic principle of why limitations should exist. So I would say these 2 days have been very good in terms of defining that. And a big contribution, and maybe with this I finish, is that in dealing with the cultural diversity of the world and enhancing the respect for that cultural diversity as the richness, we have also talked a lot about the press and the media, and how the big problem, and I certainly emphasize, and I think one of my reports should be, one of the problems with the media today, although my role is to defend the media, but I think vis-a-vis society, the media should also be open to discussion, is the fact that it has over-commercialized its role, and with an exclusively commercial perspective, it has lost the mission of being the informers of society, and that freedom of the press has the other side of the right, which is the exercise of the right that society has to be informed with diversity and pluralism. And here's where we really have to recuperate that level of diversity and pluralism, combating monopolies or the big conglomerates, the Berlusconis of the world, or the Rupert Murdochs, who have harmed the media and the press and who keep on existing, although these appear to be cases already solved. But also the monopolies in Latin America, television there's a trend to make it a monopoly, and in other parts of the world as well. And to bring diversity of mechanisms of communication, this is where internet can play an important role, because if we guarantee access to connectivity and to infrastructure, internet can be a mechanism in which all sectors of society can communicate and develop their own media online. And I think this is one of the elements of hope, but it really has to be one of our focus and one of our emphasis, is how we generate this new ethical approach as a voluntary approach from journalists, as a professional pride to be informers and good informers, and to develop within the population the sense of being also journalists when covering news and using all the media and the mechanisms of communication responsibly. This is the challenge, to really look at this sort of cultural diversity with a focus on guaranteeing plurality of views and the possible of an open and debate with a free flow of ideas. Thank you very much.
Well, certainly after this intervention by Frank LaRue, it's clear that I wouldn't make any attempt at the conclusion, because the conclusion was in a very high level, at a very high quality already done. Let me only mention a few words on further work. That's what I would like to conclude with my intervention. Seems to me, and very briefly I will touch on a few points, seems to me that one of the things that came out of these 2 days is that there are uncertainties and worries about the use of national legislation, especially criminal law, and also the role of public service in the media. This seems to me that there are 2 issues on which there should be some further work. On Frank just mentioned that to the limit of the use of criminal law, to the extreme cases, should be added also the exploration of new means. And I think that this is very important. Suggestion came from these 2 days. We have to look at administrative, at fines, at other ways to face the less, but anyway, is certainly an avenue for interesting research and work. Then the other side of this war is about the public role, was about the public media, their decline in a sense, but also their limited independence in other situations. I think that this indication of guarantee their independence from government and political influence of the public media is essential for the role that they can play in the contest. And then obviously there is the question of their financing or their more general role. That is also a theme that we are planning to work on, also looking at state aid and other rules in the European Union, but also with a special look that comes from the discussion that we had in these 2 days. Then another theme that I find very interesting that came out of these 2 days, that is brings to further work is this importance of the fair representation in the media of diversity. This is a clear major theme about quality of media, and I think that on this we should keep a focus that probably we should have in the center more than what we thought at the start. We should probably have a specific investigation on specific themes like gender representation, minority representation, and probably the idea is look also for best practices, not only for worst thing, but also for best practices. I think that this call of Frank LaRue for prevention is in this direction. The idea is to look for what are the best practices, what can we investigate this, and this seems to me another theme. A third theme I wanted to mention is, that came out of this today, is the power of new media and their use to enrich our understanding of society. This is clearly a major theme. The example of the London riots and how they were used is very interesting. Here, however, we have first to understand. It's clearly that we have to have a better understanding of how these new media are affecting, are working, how they are affecting the change of society, how they are affecting both the freedom of expression, but also how they are creating polarization, how they are creating walled gardens, self-selection of news. These kind of issues, I think, are very important issues on which we have to first understand before then intervene. Then there was the discussion, very interesting, yesterday on the intermediate liability. And here I think that the question is really an equilibrium, the search for an equilibrium solution, because I think that a solution should be looked upon among common and applicable principles. Common means, in my opinion, that they are the same basic principle that should be the equilibrium principle for freedom of expression and instead other fundamental value, but applied to the different situation of the new media. That is different. So we have to look for solutions that can be realistic, levels of control that can be really applied if they are needed, and also to the different equilibrium that we have to have when we look at user-generated content respect to professional content. All these are issues that should be investigated more and should be part of the future of our future work. It's clear it was noticed that institutions were not probably ready for this change and this quick affirmation of new media. But rarely institutions are ready for changes of this kind. Institutions often have to follow this kind of changes. The question is if they are able now to react and to follow. Then there is the question of the measurement of pluralism that was discussed this morning. Is an interesting issue. That is important to spot the risks in time, and we are the media monitoring project. We are considering at the center an idea of choose 2 or 3 countries, different countries in nature, and use and try to have an example of application of the media pluralism monitoring project. It's a project that is still there. We'll have our first event of this center will be a workshop at the end of April exactly on the techniques, on the methodology of pluralism measurement. And we hope to have some contribution from other activities and other projects that have been around, including the media pluralism project, at least as a model of looking into the pluralism measurement. Then there is the question of transparency and governance of the media enterprise. Here there were many, this theme came many times as a question of if there is probably the best way in which the question was put is if there is a space for reward of quality journalism that goes beyond the economic result. How can we have an organization of the media enterprise can deliver this higher quality result? These are not easy questions. We hope to be able to look up in depth to say this kind of question. I recall again that we are having a summer school for journalists that will start this summer in June, and we'll have, I think that quality journalism and especially investigative journalism will be at the core of the summer school activity. So we want really to look into this issue of the possibility to have rewarding for quality journalism, even in this new media environment that is changing and is putting a new challenge. Then let me say that was mentioned by Peggy Valke, she's not here now, this event at the European Parliament that she's organizing with a British colleague as a citizen initiative for freedom of expression, and we support this initiative. We'll do what we can to help Peggy to have a successful event. We invited any of you to help for this. That could be a very important appointment for pluralism in Europe to increase the awareness of the importance of pluralism. Then clearly, and this was one of the things that was discussed in the last section, there is the question of the competencies of the European Commission, what the European Commission can do to improve pluralism. We know that there have been attempts, they have been broken by political concern. There are, as we heard, initiatives from the people, from organizations that try to call for a directive that comes from people initiative. As I mentioned yesterday, we'll do our part in this sense. The Commission has asked us to concentrate our effort on the study of Commission competencies, and ask us to write a policy study about what are the possibilities in this economic and social and legal context. And we'll work on this, and this is a call for any help that we can have from everybody. And when we'll have done this study in the next months, we are planning to have a major conference in next October in which we want to discuss the results and have the occasion to compare our result and our reflection, because we think that this is the way to translate work, policy studies in action and in decisions. At least is one of the ways. So we are very open to contribution. And let me say that on this I would conclude, but let me get the occasion to thank the group of the Open Society Foundation that organized this event and contributed to have this event, Marie, Francesca, Mark, Costanza, others that I may forget, but I want to thank all of them. Let me also thank our group here, Paula, Elda, Lina, Giovanni, Andrea, that worked hard for the event, very quickly organized, because it was a surprise in a way, this event. And finally, let me say that this event and the major thanks are for Frank LaRue, because with his visit and his action, he was the catalyst of this initiative that was very important. Thank you very much.